Thanks everyone for joining us for the legal update session. During this time, we ask you please ensure your microphone is muted and your video is off so that we can listen to our speaker without distraction. There will be a short question and answer session at the end of the talk. So if you think of any questions during the presentations, please use the chat function, which will be at the bottom of your page. You just have to move your mouse down there and to share your questions with us. At the end, I'll collect questions and read them to Mitch. We hope that you enjoy this conference. After the session, I encourage you to head back to the home page and you can watch a short video from Mitch about how SNAP has helped his clients. If you're financially able to and so moved, there is a link below there's a link below the video to donate. And this gift will help SNAP offset the cost of this conference. Our speaker today is Mitchell Garabedian. He is the attorney portrayed in the film Spotlight. He has represented hundreds of clients in lawsuits against the Catholic Church for sexual abuse. He was the lawyer who started the case against former priest John Gagan, and he would go on to represent 118 alleged victims of Gagan. He and his firm have obtained millions of dollars in other settlement cases for survivors against the Archdiocese of Boston. Welcome, Mitch.
Thank you. I'm attorney Mitchell Garabedian, Boston, Massachusetts. I'm sorry we can't meet in person, but I'm glad you've joined in, and certainly I'll take any and all questions later on. I hope you're safe and healthy and COVID-free and that your loved ones are. It's certainly crazy times, and we all have to stick together and stay together. Now, it's an honor to speak to you. It's an honor to represent victims of clergy sexual abuse and sexual abuse. Thank you for allowing me and other advocates and attorneys to stand on your shoulders. It takes an enormous amount of courage to come forward and report being sexually abused. I don't have to tell you that. I've learned that from you. It takes an enormous amount of courage to confront a universal power like the Catholic Church. It takes an enormous amount of courage to come forward and speak the truth to that power so that they're held accountable. And we all know that by coming forward as you've come forward, it's empowered you, it's empowered other victims, and made the world a safer place for children. Again, it's an honor to speak to you and to participate in this conference and have you listen to me. I learned so much from you, and I thank you so much for that. And again, I hope everyone is safe and healthy. I'm going to talk about the legal aspects of being sexually abused. We have to decide what makes you heal, what will help you heal, what will help you to obtain a degree of closure. And you're in charge of that. You have to give the advocates and the attorneys feedback as to how you can heal, how you can gain validation, how you can gain a sense of that self-worth that you lost, or self-esteem that you lost, through no fault of your own. How you can rid yourself of that unnecessary guilt which you feel through no fault of your own. The question in any case is, how can I help you heal? How can the victim heal? How can the victim cope with with the trauma of being sexually abused as a child or as an adult? It really doesn't, either one. How can you heal? How can you gain a sense of validation? How can you understand, well, this wasn't my fault. Now I feel as though I can cope with this on a better level than before I saw a lawyer, or I went public, or I saw an advocate. That's the goal. And on the civil side, we use money to get that validation. It's not and there isn't one victim I've ever represented, and I've represented thousands of victims. There isn't one victim I've ever represented who wouldn't give all the money back in the world for not having been sexually abused. But in our system, on the civil side, we use money to validate claims. On the criminal side, we use criminal penalties. We use guilty findings. We use jail. And so the two, I'll talk some about the civil side and some of about the civil criminal side. But the question always is, how can you heal? What can help you heal? Will going public with your claim help you heal, or will it cause more damage? Are you ready to do that? Will going public with your claim help you heal because you feel as though you're warning the public, that you're protecting other children, that you're serving a useful healing purpose? Church doesn't care about you. They never will. And some may disagree with that. Some on this call, and I don't mean to offend you, but they've circled the wagons. Change is coming. Change is coming from the outside of that circle of wagons. We're making the public aware that clergy sexual abuse is not acceptable, and that when children are in the presence of priests, or religious brothers, or nuns, or the janitor of the church, whoever you want to pick, they should be watched. They should be protected. That's the change that's coming forward. Pope Francis can give all the edicts he wants, his vos estis or whatever. They're not changing. They haven't been changing. I've been doing this for decades, and I've represented thousands of victims. So let's look at some of the obstacles we have. One obstacle is statute of limitations. Now, what is a statute of limitations? You all know what a statute of limitations is. It's a deadline to file your claim. Have you missed the statute of limitations? Has that deadline passed? And in the cases involving sexual abuse and clergy sexual abuse, so often the deadline has passed because as a 20-year-old, as a 25-year-old, as a 15-year-old, as a 30-year-old, you couldn't come forward emotionally to beat the deadline, that filing date in court, known as the statute of limitations. You couldn't beat that deadline, because if you did, you would cause enormous harm to yourselves, and no one can blame you for not coming forward until you're ready to come forward. Myself, the oldest person that came forward to me was 87 years old. It was his time. And within 6 months, we had proven his claim, and the perpetrator, a Catholic priest, was found to have credibly accused. Every person has their own time. It's unique to the individual, so you cannot push yourself. Statute of limitations vary around the world. Canada basically has gotten rid of their statute of limitations. They followed Quebec. New Jersey has amended their statute of limitations. New Jersey even now has a window for claims that were outside the statute of limitations for adults who were abused as adults. California has amended statute of limitations. Hawaii has amended their statute of limitations. And they're amended in different ways. Rhode Island, Massachusetts have amended their statute of limitations. Vermont. Some statute of limitations are amended only against the perpetrator. Some statute of limitations are amended against the supervisors too. And why is that important? Putting aside the monetary issue, that's important because you want to be able to show and penalize this and get a judgment against the supervisor, because they were the ones who negligently supervised. Archbishop Myers just passed away, and although any death is unfortunate, many victims feel as though he wasn't held accountable for his negligent supervision in New Jersey, in Newark. It's very important to understand the deadlines involved. Sometimes a criminal statute of limitations, if the person is found or indicted even, or found guilty, if the perpetrator is, that statute of limitations could be amended through that formula. Now, we all know, or most of us know, New York State has amended their statute of limitations. They even created a window And the window is extended to August 14th of next year for any claims being filed. And we see the great effect that's having, because there are hundreds upon hundreds of lawsuits being filed, hundreds upon hundreds of lawsuits being filed in New York State alone, just alone. And it's driving these institutions, such as the Diocese of Rochester, the Diocese of Buffalo, and other religious entities in New York State, into bankruptcy, where they have to reveal not only their assets, but there is litigation in the bankruptcy courts. And I have 94 clients, for instance, in Rochester. We're obtaining documents. We've taken the deposition of the bishop up there, even though he retired. So you can conduct your discovery, which is more important than money to many victims, most victims. That's the evidence that the supervisors, the cardinals, the archbishop, the bishops, the vicar generals, all knew what was going on, all knew about innocent children being sexually abused, but did nothing about it. Statute of limitations on the civil side are totally different than the statute of limitations on the criminal side. Different deadlines, different set of deadlines. There are even different nuances to the statutes. For instance, in Massachusetts, where I'm residing now, Boston, if a person abuses someone within the statute and that abuser leaves the state and resides somewhere else, the statute of limitations is stopped. And that allows the victim later in life to pursue a criminal action against the perpetrator, because the statute automatically stops on the criminal side if a person abuses in Massachusetts and resides somewhere else in the country outside of Massachusetts. Not just leaves Massachusetts, it has to reside outside of Massachusetts. Very important distinctions. Very important that you have a lawyer, and there are many great lawyers out there who know the distinctions, who understand the distinction. And if they don't practice in a certain state, they're co-counsel with a lawyer who does practice in that certain state, which is what I do. It's very important that a lawyer understands the hierarchy of the church so they can ask appropriate questions. If they have local counsel who know the nuances in the law in that state, and representation has to be provided to you by individuals who are truly interested in disclosing the ugly underbelly of the Catholic Church. And it's there. And we're doing it because you're allowing us to do it. As I mentioned to you before, we're standing on your shoulders. Now, put aside the law for a minute. Many states are developing and have developed, New York State, New Jersey, Pennsylvania, compensation programs. What are compensation programs? Most of you know, compensation program is where you don't have to go through the litigation, but you can put a claim in, file the paperwork, and try to receive an award in the compensation program. For many victims, that's an alternative that is viable because they don't want to go through the pain of litigation. But at the same time, compensation programs have limits. There's glass ceilings, there's the dollar amounts being awarded. There's the need for corroboration many times to prove the claim. And you may not get the same sense of validation you would in litigation because documents aren't revealed, depositions are not taken of bishops, of supervisors, interrogatories are not answered. So it's a different setup. It involves a lot less participation by the survivor or victim than litigation does. Litigation involves a lot of participation by the survivor or victim. Litigation is intense. Your deposition will be taken. You have to answer interrogatories. You have to produce documents, excuse me. And what's very important in this day and age is you have to understand, as I'm sure many of you do, in our internet age, in our social media age, you have to produce any sort of text, email, Instagram message, anything that concerns your case, which is not privileged, privilege being with your doctor or with your lawyer, for instance. But you have to produce everything. And the courts don't know how to cope with this anymore because the number of email messages and social media messages are off the charts. We're talking about hundreds of thousands. And the courts don't know how to deal with this anymore. They've instituted rules of reasonableness, but lawyers are always end up in court fighting about what is reasonable and what isn't reasonable in terms of numbers, but the courts are overwhelmed with the problem. That's why many victims or survivors choose a compensation program. But again, it's an individual choice. And you may be disappointed in the compensation program because I think many of these dioceses are now understanding that just because you have a compensation program out there doesn't mean you're not going to be faced with litigation, heavy litigation, a lot of litigation, and possible bankruptcy. And plus, you don't want to give the other side a free look at your facts if you go through a compensation program that is not successful. Not that the arbitrators or the mediators would give that information to the other side, but in many compensation programs, for instance, in Rockville Center in New York, they'd like to say, we'd like to interview your client first before we determine whether they're eligible for the compensation program. Well, that's a trap. That's something you have to be very careful with, because what you say to those investigators is not privileged. They can use that in further litigation. And if they say they won't, I don't believe them. I just think they will. I think, there's nothing written in, nothing written in an agreement in writing, solid, tangible, that says they won't. They can't unlearn what they learn when you're interviewed. You can go to the review board process with the diocese, archdiocese. I strongly urge you not to. It's the epitome of a kangaroo court. You have usually 3 or 4 people, 3 people who are deeply religious and want to protect their church, and the rules are one-sided, very one-sided. There are no rules of evidence. I've seen review board hearings take place through the years, and I haven't been in very many, but I've been in enough to realize they're just kangaroo courts. Even the one, excuse me, some noise. But it's not helpful to go through a review board process for many victims because it's so one-sided, and there's no evidentiary value. You have 3 lay people basically to determining whether you're credible or not. And it's the rules of evidence are totally different. If a lawyer represents the victim and the mother who the victim told as a corroborating witness, and the review board will not allow the lawyer to sit in with the mother when she testifies, even though the mother's the client of the lawyer, just like the victim or the survivor. So you have to be careful. There are a lot of avenues here. It's very complicated, but we only can do this work because victims or survivors have the strength to come forward and allow us to do this work. There are many, many issues in litigation. One was statute of limitations. Another is notice. You've probably heard that phrase. When you're trying to prove your case against the supervisors, they love to say through their attorneys, if we had only known that this victim or survivor was sexually abused, if we had only known that the perpetrator was a bad person before the sexual abuse actually took place, then we would have stopped it. We all know that's a bunch of baloney because we keep proving through the secret files they did know, but did nothing. But that's the argument they use in court, because the law is if there is no notice that to the supervisors that the pedophile priest was a bad actor before the abuse took place, then they had no reason to stop it, to watch him closely. When in fact, the arguments we're using are, well, if a person is abused over the course of 5 or 6 years, they must have had some procedure, or once, they must have had some procedure in place, and they weren't following that procedure. Another argument is, and I've been successful with this argument, is, well, they didn't know he was an abuser, but they knew he had a temper. They knew he was a drinker. They knew he was hanging around with the children at the wrong time of day. And judges said, you know, that's enough. That's enough to show they should have watched this guy, but they didn't. And I mentioned the secret files earlier. Secret files or secret archives under canon law are where the bishops keep all the dirty records about the abuse. Bishop Malone kept them in his closet near a vacuum cleaner in the Diocese of Buffalo. It took us 3.5 years of litigation in the Gagan cases beginning in the late 90s to get to the secret files in Boston. And we showed that Bernard Cardinal Law knew that Father John J. Gagan was sexually abusing innocent children and did nothing about it. He didn't warn parishioners, he didn't warn the public. And after he knew that Father Gagan was sexually abusing innocent children, Father Gagan continued to sexually abuse in St. Julia's in Weston, Massachusetts. And even when he was in your retirement home, I've had 153 cases against Father John J. Gagan, which surprises none of you who've lived through this. It surprises no one on this call, in this video. So you have notice. Notice is very important. And you prove notice through litigation, through corroboration. Many of you in this video have had loved ones who you told as children or when you got older who reported to the church. And after it was reported to the church, the supervisors did nothing and let other children be sexually abused. You have purportedly the most moral institution in the world acting the most immorally. There's no excuse for it. It's all about their greed. It's all about their desire for power and money and influence. They didn't care about innocent children or innocent adults for that matter. So you have compensation programs. You have civil litigation. You have criminal litigation. Now, looking at the statute of limitations, let's go back there for a minute. There are other issues with the statute of limitations. Statute of limitations, as I said to you, are deadlines. You have to file your suit by a certain day according to the law. And there are look-back windows being created, as I mentioned, windows where if you're outside that deadline, the legislature has passed statutes saying, even though you're outside the deadline, you have X number of days to file a lawsuit anyway. It's like a grace period. In New York, they've increased it. It was 1 year, it's 2 years. In New Jersey, it ends, I believe, the end of November of next year. Pennsylvania may be creating one. They claim they need a constitutional amendment to do so, which is just doesn't make any sense at all. They don't need one. Other states, like Vermont, have done away with the statute of limitations. Some statute of limitations don't relate back, though. Some statute of limitations say statute of limitation only applies if you abuse today or into the future. In other words, if you abuse today or into the future, if a person is, there's no statute of limitations as to when they have to come forward, but they don't help people who are already outside the statute of limitations. Some laws are like that. Connecticut just increased their statute of limitations a little bit by, I believe, 3 years from 48 to 51. but it doesn't help people who are already outside the statute. In other words, if you were 49 when they passed this law, it's not going to help you because you're already outside the statute. Very critical. And I really think you have to support the advocates and be very supportive of anyone who wants to amend statute of limitations. Address it with your legislature, address it with your state legislatures so that we can get statute of limitations amended in states. And they've been amended in many, many states. And there are certainly a need to keep amending the statute of limitations. It's all about you healing. It's all about you gaining a sense of validation. It's all about helping keep society safe. It really isn't. It's only common sense. It's only common sense, and I don't have to explain that to you. We often think of statute of limitations as being something that shouldn't exist, and you're right, it shouldn't exist, but the people on the outside don't understand why they should be extended, because you'll often hear, well, how are you going to prove a case that's 60 years old? Or how are you going to prove a case that's 40 years old? Or how are you going to prove a case that's 38 years old? The witnesses have passed away. The evidence has disappeared. It's a question of due process. It's a question of procedural due process and substantive due process. The defendant has rights, you know. Well, my response to that is, in murder cases, there is no statute of limitations. And procedural due process and substantive due process rights are fine. The defendant's rights are protected. And since child abuse is sole murder, we should have no statute of limitations retroactively. And looking forward prospectively in child abuse cases. Since it works fine in the criminal context, it works fine. It will work fine in the civil context. And the response I get is, oh, gee, I never really thought of it like that. Well, it does work fine in both realms. Often when you have a case, there's an issue of credibility because of corroboration. Who did you tell and when did you tell them? And many, many victims tell individuals later in life, maybe 10 years before they came forward, maybe 15 years before they came forward, maybe 5 years before they came forward. Those individuals that they told are very important, because if you were just trying to bring a lawsuit to say, as the defendant say, to make a buck, why would you wait 10 or 15 years? If you told someone 15 years ago, you would have come forward 15 years ago. My argument is, no, you can only come forward. And I'm sorry, if you told someone 15 years ago, you couldn't come forward 15 years ago to the courts because you weren't emotionally ready. And if a person really was fraudulent, they would have come forward back then. But they weren't ready. It's not about money, it's about validation. Many, many victims have gone, or survivors have gone through broken marriages, for instance. But they told the spouse 15, 20 years ago. I've called those spouses from 15 and 20 years ago. And as bad as the breakup was, they'll still say, and with a tear, they'll still say, yeah, he or she told me, and I believe them, and I'll do anything you want me to do, because it destroyed his or her life and it destroyed our marriage. So if you did tell anyone in the past and you think they're going to be upset by being contacted, think twice, because the corroboration is very important. And that person you told, as bad as the marriage was, as bad as the friendship was broken, still may speak up on your behalf. I think it's very important for you to understand that. Let me check my list just in case I want to cover anything else. There's another concept called fraudulent concealment. Pennsylvania had it in a major way for about 2 years. Fraudulent concealment is another way to get around the statute of limitations in some states. And this law is totally different from state to state to state. But the general concept is the victim has a right, or the survivor has a right to come forward from the day they're told that the institution knew about the abuse or knew that the perpetrator was an abuser, but withheld it from the public. When the grand jury report came out in Philadelphia, Pennsylvania, a lot of lawyers used that as a 2-year window because they said that the Archdiocese of Philadelphia fraudulently hid the evidence. And the court said, yes, you have 2 years to file a lawsuit from when that evidence came out. That's being tested in higher courts in Pennsylvania. Massachusetts has a fraudulent concealment statute, but it's a twisted statute. It doesn't make any sense. What it says is when you're abused, that's when you realize there was fraud being committed. So you have 2 years from when you were being abused, even if you were 16 years old or 20 years old or 15 years old or 13 years old. So it doesn't make any sense. If you were a minor, though, you'd have 2 years from 18. So it doesn't make any sense. And fraudulent concealment statutes vary from state to state to state, just like statute of limitations vary from state to state to state. I've had cases in probably half the states in the country, and they vary, and some of them are horrible. Even the amendments are horrible. You have states like Ohio where it's age 30. You have other states where it's age 23 or 22. And it's just horrible in many, many states. And there's a lot of work to be done to amend the statute of limitations so that victims can try to heal and children are protected in their lives against sexual abuse. So just to review this for a minute, you've got the criminal process. Now, if you report, as I'm thinking about it, if you report the abuse to criminal authorities, in my opinion, it gives you a lot of credibility. And you'll hear victims or survivors say, well, you know, what am I going to do? Walk into the police station and how's this going to go? And I don't know if I can handle it. That's not what you do. You call the police department up and you say, I want to make an appointment. Why? I want to report being sexually abused by a priest as a child. Why? I want it documented. Why? Because I want the world to, I want you guys to be able to watch this person so the children in the world are safe. Well, he's dead. I still want it documented so that other victims can feel empowered and the church can understand, or church is notified, I should say, that what they've been caught and what they did was wrong. And the police honor that. The police are never, and what they'll do is they'll say, come in at this time and we'll have an hour or 2-hour interview. And they'll never force you, if you're within the statute of limitations, to prosecute. They'll ask you if you want to prosecute. And they'll tell you, excuse me, whether you have a strong case or a weak case, but they'll never force you to prosecute. But you've documented criminality. And that helps you in your civil case too, because it gives you credibility. But in just isolating the criminal aspect alone, you've documented that criminality so that it's known this abuser is a bad guy. The abuser, a bad person, man or woman abuser, male or female abuser, is a bad person. Don't walk into the, well, you can do whatever you want. Maybe you'll have some benefit to it, but I never tell a victim or survivor, just walk into the police station and say, I want to report this. I tell them, call the police department up, make an appointment. They bring in their squad that's familiar with interviewing victims, and they ask you all kinds of questions. Even with the Penn State, with Sandusky, I had state police in here who wanted to speak to my client. Sure, no problem. They drove up from Pennsylvania. And if you live in another state, let's say the abuse happened in Massachusetts, or it happened in Connecticut, or it happened in Wyoming, but you live in Oregon, you can often set it up so that you can go to a police station in Oregon and they'll report the abuse to the state where the abuse occurred. In other words, if you live in Oregon and you go to the Oregon Police Department, they'll report it to Connecticut if it happened in Connecticut. That's where that's in terms of jurisdiction, that's where you bring your lawsuit, where the abuse occurred. Even if the priest was from California, but the abuse happened in Maine, you have to use the Maine statute of limitations law. And there are international laws too. I had 153 claims in Haiti against Douglas Perlitz. He wasn't a priest, but it was a Jesuit-run school, Fairfield University-run school, Order of Malta-run school in Haiti. And we litigated for 7 years in Haiti. I co-counseled with Simmons Law Firm. We litigated for 7 years. We were in Haiti. They took deposition after deposition after deposition of my clients. And we finally settled these cases. 153 cases, we settled them for $60 million, but it was deposition in Haiti. Now, in Haiti, before COVID, there isn't any food, clean water, medicine. These children had nothing. And the Jesuits already showed up, and they were supervised by Father Paul Carrier, a Jesuit out of Fairfield University. And he allowed the abuse to take place. They didn't, no clothing, food, no medicine, nothing. If you're hungry, it's too bad. And the Jesuits, Fairfield University, Order of Malta, allowed this abuse to go on and on and on. Homeland Security got involved. Here's my example with the police. They went down there, they got involved. And Douglas Perlitz got, I believe, a 19-year, 10-month federal prison sentence. He's in prison right now. We went down to Texas to depose him, where he pled the Fifth Amendment every time we asked him a question, except for his name and address. So the police were in action. Because of the police, Perlitz pled guilty. It wasn't even a trial. He abused child after child. I think I've 175 victims I've represented in Haiti, Douglas Perlitz. But that's an example of the police in the criminal system working hand in hand with the civil system. Because we filed under sex trafficking laws in the United States. We were able to find jurisdiction, which I mentioned earlier, in Connecticut, because Douglas Perlitz, the perpetrator, used to come to Fairfield University, and Father Carrier was out of Fairfield University. As a matter of fact, Douglas Perlitz gave the commencement speech one year at Fairfield University, and he was abusing these children in a wholesale fashion. It's just story after story, and it's just so sad, but because you're coming forward, we're putting an end to this. You have great advocates. You have Bishop Accountability, you got SNAP, you got Road to Recovery. You got so many advocates. And they need your support. They need your emotional support, your financial support, especially in these times. We're working together as a unit. I know I'm standing on your shoulders. I've been doing this for decades. But we have to keep fighting. We want to keep going. Let me check my notes again, please. You know, I just want to address the COVID issue for a minute. I know a lot of victims, and I've heard this from a lot of victims and survivors, they're feeling extra stress because of the COVID situation. And no one can blame them. It's totally understandable. Courts haven't stopped, though. We're using video, we're using Zoom. I have many cases, for instance, New Jersey, we just had a major court hearing in New Jersey, same with New York. So the courts haven't stopped. Physically, it's changed. Of course, you can't go to court and you can't file your papers physically, but we're adapting to this new normal so the cases are proceeding, and the criminal cases are certainly proceeding. So don't let that be a deterrent in wanting to come forward, because your rights are there and you should exercise your rights to try to heal. I know it's caused an enormous amount of stress on everyone. The COVID situation has caused an enormous amount of stress on everyone. And I admire you for participating today and for moving forward with your claims and being interested in moving forward with your claims. It takes a lot of courage, an enormous amount of courage. So what's involved in litigation? Let me just say, it takes a lot of work on your part. You have to be ready to uncover every dark secret in your life, because in measuring case, when you claim emotional damages, which bringing a tort is, which saying, when you're claiming you're sexually abused and you're suing for negligence or supervisory negligence, you're claiming emotional damages. When you're filing an emotional distress claim, you're claiming emotional damages. It's very important that you know, not only you're going to have to participate quite a bit in the case because you're the best source of information, and you're going to have to answer interrogatories truthfully, and you're going to be deposed, and your friends are going to be deposed, and your ex-spouses are going to be deposed, and your cousins, and your brothers, and your aunts, and your uncles will be deposed. You're going to have to reveal secrets other than sexual abuse that you've never told anyone in your lives, because they have a right, for instance, to your therapy records that and many people have been to therapists their entire lives since the abuse. They have a right to those records, and those records may say things that you really don't want out there. But they have a right to look at those records. They don't have a right to put those records out there publicly. So I don't want you to think I meant that. But they have a right to look at all the information in your life. Whenever you put emotional distress damages into play, they have a right. And I'm not talking about a breach of contract case where it's just measured, my car was broken and it was a lemon and I want my money back. That's not what we're talking about. We're talking about your emotions, your lack of self-esteem, your unnecessary guilt, unnecessary shame, whatever you feel. I really don't want to get too deep into the damages because I don't want to take you there, but we all know that victims of clergy sexual abuse and sexual abuse suffer an enormous amount of harm since the abuse occurred. And they're repeatedly abused by other individuals, often too. They feel like they have a target on their backs. You're making very powerful statements by coming forward. Let me please check my notes again. Yeah, New Jersey has an interesting statute. If you were abused as an adult in New Jersey, you can file a lawsuit under their window, even though the statute has run. And you have until next November, next year. So it allows victims who were abused as adults to file lawsuits too. You don't find that too often. I haven't seen it anywhere else. Of course, if you fall within a statute of limitations as an adult in another state and you're abused as an adult, you can. but they created a look-back window for victims of sexual abuse in New Jersey who were abused as adults, where the statute of limitations has already run. At this point, I'll take any questions or comments you have.
Okay, I will read you some of the questions that we've gotten in the order that they're received. First, Daryl wondered if you had any update on the RICO investigations by the Department of Justice.
I do not, I'm not quite sure. No, I don't. I'm not quite sure of the question. RICO concerning anyone in particular?
Let me see if I can go back up. No, sorry.
No, it's okay. All I
Anyway.
can say is with this conservative approach we have from the Department of Justice, don't hold your breath.
Sounds like a good idea. Okay. Kevin wondered if about the SOLs for someone who's abused on a military base.
It depends if the person's in the military or not when they're abused on a military base. That's a very good question. The statute of limitations may or may not apply. We all know and we've all read about the enormous amount of sexual abuse within the military. And I think it depends where the base is and whether the person's in the military. Certainly if it's in Guam, I mean, Guam has just been in the news for years now about sexual abuse cases being successfully brought. So I think you have to look at the military base and whether the person was actually in the military with regard to that issue.
Okay, this is from John. How does the diocese filing bankruptcy affect your claim?
Well, many victims will say, oh, I just got the short end of the stick because the diocese filed bankruptcy. I don't think that's a bad thing necessarily, because through the bankruptcy court, the diocese is basically saying to the court, please help us survive. We're going to get crushed here, okay? And the judge is basically saying, well, I'll help you survive, but you have to play ball here. So for instance, in Rochester, they had to produce the secret files. They had to produce the documents. We took the deposition of the bishop. So the case goes along on a discovery track. And at the same time, the diocese has to reveal its assets. And of course, they try to hide the assets in the bankruptcy court. But the litigation in the bankruptcy court is geared with the judge focused on accessing the assets. In addition, there's insurance in these cases, and the diocese is arguing with its insurance companies over liability, but the judge pulls everyone into the same room, figuratively, not literally, because there is so much insurance coverage over decades. There's tens of millions of dollars in insurance over decades. I mean, hundreds of millions. So it's not a bad thing. So you're able to continue litigation, and yet they have to reveal their assets in bankruptcy court, which you don't find in state court actions. So it's different, but it's not a bad thing because I think it's more pointed. And in bankruptcy, the first thing the trustee does is, one of the first things he does is he sets up a committee of victims who get to vote and decide, following the guidance of their state court counsel and the creditors counsel, as to what to do, what direction to take in terms of when to go to mediation or not go to mediation, for instance, when to ask for documents or not ask for documents, when to take depositions or not take depositions. Thank you.
Okay, this is from Eduardo. Do you represent victims across the nation or only in a certain part of the country?
No, I represent victims in not only across the country, but around the world. As I mentioned, Haiti, for instance, I represent victims in at least 12 or 13 different countries, but many, many states in the United States too. I mean, been doing this, Canada, been doing this for a long, long time, and it's an honor to do this, and it's work that has to be done and can only be done while standing on your shoulders. So, pick the states. I've been involved in many, many states from Maine to California, Hawaii, um, Ohio, Pennsylvania, Florida, pick the states, Michigan, going on and on and on. And you'll find that it's that the perpetrator went from state to state to state to state, like Brother Stephen Baker, a Franciscan, TOR. He abused, I believe I had 86 clients of him. He abused in 3 states. So I represented the victims in all 3 states. He was at the same organization. They transferred him around, as you all know, from parish to parish to parish to get him out of Dodge.
Okay. Mark wanted to know if moving children across state lines affected the statute of limitations in the home state.
Yes, that can bring in federal statutes. Now, you want to be a little careful if you're suing in federal court, because in federal court, you don't get the same discovery amounts that you get in state court. In federal court, they limit the amount of depositions, for instance. And these cases are deposition intensive. In the Gagan cases, we deposed over 100 priests. That would never happen in federal court. So you want to pick your jurisdictions carefully.
Okay, this is from Julie. Her perpetrator priest died. The diocese is in bankruptcy. She has 2 family members and herself that were abused. Does she need a witness to come forward? Or
Well, first of all, just because the perpetrator died doesn't mean your case is weak. It just means the perpetrator, in many cases, just can't say it didn't happen, because who you're really trying to sue also are the negligent supervisors. So you really want to be aware of that. Now, in some states, you can't sue the perpetrator if he died after a certain number of years, but that doesn't mean you can't sue the diocese or his supervisors, which brings me to one other issue, and I just want to touch upon this. In Massachusetts, for instance, we have this archaic law called charitable immunity, where you can only, when you sue the Catholic Church, which is a charity in Massachusetts, the most you can get is $20,000. So you don't sue the charity, you sue the supervisors only, so you don't have to deal with that cap, because if the supervisors are paid employees, which they are, and they're insured, which they usually are, then there's no cap like that. So you want to you don't want to go to a state that has any sort of charitable immunity, and there are very few of them left. Massachusetts happens to be one of them. All the universities here and hospitals, churches, they're all charities.
okay,
Can you repeat that last question? I went off track there.
sorry. Okay, she said her perpetrator had died. The diocese is in bankruptcy. Herself and 2 other members of the family were abused, and she wanted to know if she needed a witness to come forward.
No. More witnesses you have, fine, but you have patent and practice, which is often used in court to show if they were close proximity in time, similar circumstances, you can show a patent and practice of sexual abuse, which would be very helpful to your case. And it's often a defense tool to say, well, no one else sexually abused the victim, so I don't know if we can believe them. When in fact now you have 2 siblings who are also abused, and so they can't use that defense, which is very powerful. And which I want to segue into this. That's why sometimes you want to make your claim public, even if you're anonymous, so that when you empower other victims to come forward who were abused by the same perpetrator, the defense can no longer say, oh, but well, I don't know if this really happened because no one else has come forward in all these years saying they were abused by this perpetrator. You defeat that whole argument. It's very important. What's next?
Okay. Anne wanted to know if you thought bankruptcy filings led to more disclosure or how they would do it.
Well, as I touched upon earlier, you get a lot of discovery in bankruptcy court, but you get just as much in the state court. But in the bankruptcy court, the judge says, listen, you've got 300, 500, 1,000 victims here, different perpetrators. Just give us all your records, because he's saying that to the diocese and basically saying, if you want me to help you survive in the future financially, you have to help me. So give me the records. If we're going to argue about this, I'm not going to help you. I won't even approve the bankruptcy. He doesn't say it that way, but that's what's going on in bankruptcy court. Is you have to work with me if I'm going to work with you. He's saying to the diocese, if you want me to protect you in the future, then you have to work with me. Give them your documents. Don't play games. And what you have to understand in bankruptcy court is it's very important that your state court counsel educate the bankruptcy court about the uniqueness of a clergy sexual abuse claim. These judges are used to dealing with widgets. The widget company went under. And we have to now work with the widget company so they can survive. They're not familiar, many of them aren't, with the damages of the sexual abuse of children, clergy sexual abuse of children, the First Amendment issues. They're just not familiar with it. And I found I've tried to educate the judges, and they're all receptive to being educated, but they're used to the widget cases, I call them. They're not used to cases like that. Many of the judges, for the first time, will have a clergy sexual abuse case, and they start talking about how proof of claim forms, you need to check off the boxes or whatever. I'm like, no. It doesn't work like that. They're revealing their souls here, and they want to tell their story, and they want transparency. So it's very important the judges understands that. And they're always receptive, don't get me wrong, but they're just not used to dealing in this world of clergy sexual abuse.
Okay, this question from Karen. She says a lawsuit is a matter of public record, right? And she wants to know if the any bankruptcy filing changes that.
No. First of all, when you file a lawsuit, you can use your name. If you want to call John or Jane Doe, you can go through the proper procedure in a court to have your name impounded. You don't ever want to impound the whole case, because that's just what the diocese wants. And you have a lot of leverage with the public filings in your case. Now, again, you can keep your name as anonymous. So you can use a pseudonym. You can be called Jane Doe. You can be called John Doe. But you don't ever want your case to be sealed, because the secrecy is what allowed clergy sexual abuse to exist and grow, and what is keeping it current. And we want that secrecy to end. When you file in bankruptcy court, you'll still be known, your case is filed in bankruptcy court, and you whether it's the lawsuit or a proof of claim, you can be known as John or Jane Doe. You don't have to reveal your true identity. And it's more than your name, it's your identity. In other words, it's pointless if you're going to just call yourself Jane Doe, but put down your residential address and your telephone, well, not your telephone number, but your residential address so anybody can find you. It's your identity. It's just not your name. And when you get there, when you have the courage, when you have the strength, use your name, because it sends a loud, clear message to the diocese, to the archdiocese. We're not fooling around here. We're going to go right after you. But if you can't, that's fully understandable. It's an individual decision. Again, it's part of the healing process. Where are you on that healing process? That man I talked about earlier who came forward when he was 87 years old, I asked him why he was coming forward then. He said, because everybody in my life who would be hurt by this news has now passed away. He was found credible and he passed away within 6 months of being, and he was in good health, but he passed away within 6 months of being found credible. Next question, please.
We are out of time. So we have a lot more questions, but this is the end of our session. So I don't know if your contact information is available someplace if people want to.
Sure. It's garabedianlaw.com. GARABEDIAN law, LAW.com. Just give me a call. Give me a call at 617-523-6250. Go to my website, garabedianlaw.com. Just hit the contacts list. Send me an inquiry, and I'll get back to you. Please be a little patient because sometimes I get a lot of inquiries and I can't respond to them all at once. Third time, garabedianlaw.com. It's been an honor speaking to all of you. I wish you nothing but the best. Please stay safe and healthy during these crazy times. Thank you for letting me stand on your shoulders.
And thank you for coming and talking to everyone. And you stay safe and healthy too. We need you.
Thank you, Melanie. Thank you. Bye.
Bye-bye.